installment of the MP Access podcast. I'm David Wharton. I'm the editor-in-chief of Mortgage Point and the 5 Star Institute, bringing you conversations with some of the industry's subject matter experts. We are speaking today to Robert Forster. Welcome to the podcast studio, sir. How are you?
Doing very well. Thank you for having me.
So to get started, tell us a little bit about kind of the elevator pitch of how you got to where you are. How did you decide to enter law? How did you end up in this section of law? Tell us how you got here.
Absolutely, and I will try not to put you to sleep straight from the beginning. I was born and raised in Little Rock, Arkansas, the son of a federal judge. He was adamant, do not go to law school, do not follow in my footsteps, all that stuff. And most of his friends were lawyers. They told me, of course, I dismissed it and ended up where I am. But I was always, unlike a lot of lawyers, I was always fascinated with numbers, and I was sure I would end up in some form of finance, outside of the law completely. Ended up going to got my undergraduate degree at Arizona State University. Absolutely love it out there in the desert. My only regret was graduating in 4 years. And then it's time to get a job, and it's like, well, got to follow in Dad's footsteps, go to law school.
Ignore every step.
Ignore every step. Absolutely. History repeats itself. Yep. And you kind of fast forward a few years, and I went to law school at SMU, just down the street here from where we are in Dallas, and I immediately took a job with a personal injury firm. So I was literally in remote courtrooms in the farthest corners of Texas before juries, trying cases over hundreds and sometimes just thousands of dollars in medical bills, which is the exact opposite of what I'm doing now. But those things really, really shaped my career and my focus. And what I really gathered from that I've carried on to what I'm doing today is it's about clients first and then results, of course. So I did that for a few years, ultimately then began with our firm, with the BDF Law Group, was formerly Barrett Burke and a bunch of names, but started there in 2006 as an associate attorney, very bottom of the barrel, worked my way up, kind of a great of American dream thing if you think about it, supervising attorney, managing attorney, partner, and since 2018 I've been the managing partner. So I oversee legal operations in all 10 states of our footprint.
So when you started at that lower level with the firm, whatever letters it had in the name at that point, were you intentionally drawn to the default side of things? Was that an intentional choice? Was it just that's kind of where your career took you and you just followed that path?
Yeah,
how did you end up there?
It's interesting, and it kind of goes back to my initial desire to want to be in finance and not necessarily a lawyer. So all of a sudden I'm offered a job and I'm not going to lie, I didn't even know what a foreclosure was. They don't teach you foreclosures in law school.
Yeah.
So I wasn't exactly sure what I was getting into, but I knew that it was very much an intersection of law and business. And ultimately at that point I already had a JD from SMU, and I always have had that interest in business. So I thought, this is a great place. Let's check it out.
I'm curious, from those initial thoughts or impressions, were there surprises early on other than having to figure out foreclosure law as a concept? What surprised you in those early days?
Oh, absolutely. Well, the banks.
Okay.
The banks surprised me. I was completely unfamiliar with how complicated things are and compliance and oversight and how that all plays in to what you do. And, going back to my prior experience as a personal injury attorney, it is kind of like Al Davis with the Raiders from a long time ago. Just win, baby. It's all about results. Well, winning in the default mortgage servicer space is not necessarily winning in the courtroom. It's winning on a business decision, which may not necessarily be a win for the lawyer. So putting your clients first is important, but that's not always about winning per se. So that was extremely difficult, and it took a few years for me to wrap my head around that.
Was there a moment where you sort of got it, or was it just kind of an ongoing process of having to rewire your brain on defining success?
I'm actually going to steal the rewiring your brain from you, because that is exactly what happened. Again, back to my being intrigued by the business aspect, all these things in real estate and the promissory notes and the investors and the mortgage-backed securities and how that played into it, that was all extremely exciting to me. So I enjoyed learning that. But I did have to apply those skills to my prior skills in the courtroom. But again, because I enjoyed it and was interested, it made it all that much easier for me.
Now, you've obviously been with the firm for some time, coming in right before the financial crisis of 2008, and you've seen a lot of changes, I'm sure, over those years. So what would you say sets your firm apart from your competition and sets you guys apart within the industry? What do you do well, and what is the promise you sort of make to your clients?
Yeah, absolutely. I mean, I think there's three things. We have the consistency, and I think the consistency reverts back to our founding partner, Michael Barrett, who, bless his soul, he's in heaven now, but he was still working at the firm and actually hired me, so I consider him a mentor. And he had many principles, we call them Barrettisms, inside the firm to live by. Clients always right, customer service first. So consistency through Michael Barrett, learning those values, carrying them forward has been great. And we still do that through today. You also have the people. People are what makes everything, of course, right? The best leader in the world, the best lawyer in the world, if you don't have staff behind you and people who are buying into it, it's not going to work. Well, I take great pride in the fact that we have hundreds of employees, and still to this day, the average tenure is over a decade with our firm. So that's great. And then last would be just the integrity. You've got to do everything with integrity, whether that is dealing with the borrower who's on the opposition or dealing with your clients.
You mentioned those Barrettisms and interacting with him in a mentor perspective. Have you, now that your career has continued on, have you had the chance to sort of flip that dynamic and pass your mentorship on to attorneys that are coming up in the firm or other people? And what lessons have you tried to pass on beyond those Barrettisms? Is there anything that you think is important that you've instilled in folks?
Well, absolutely. I think attitude goes a long way. And focusing on the small things, especially in this industry. As everybody knows, it's so much more than practicing law. There are operational details, and there are so many small things. And messing up any small thing throughout that process can result in a big error for the client, for the law firm, perhaps even putting everybody's reputations and license at risk. So small things end up being big things. And if you can focus on the small things and really place a lot of emphasis on doing that, big things will come.
Well, going back again to just the changes you've seen since starting, in that just, I don't want to call it opportune and inopportune, but certainly about to be very busy time there before the financial crisis. What are some of the biggest industry changes you've seen over the years, and both long term, and then what have you seen change in the last year or so?
Yeah, that's a great question. And I have been in the industry long enough to see a lot of things, ups, downs, then COVID. Sure. And now we're kind of seeing some ups again, not quite to the pre-COVID level, but it's interesting. Back in 2008 with the great mortgage crisis, you look at ultimately, what prompted that was somewhat subpar underwriting standards, right? They called them ninja loans, no income, no job, lack of paperwork. Well, then it got overregulated, I feel like, to a certain extent. And then you have the creation of the CFPB. All of a sudden, many states are even have very strong consumer protection agencies. So it used to be you're concerned about complying with federal laws like federal debt collection laws, FDCPA, things of that nature. Now you have state layers on top of it. I mean, heck, back in 2008, 2006, when I started, we didn't even have a compliance department. Well, now I believe 11% of our overhead goes directly to compliance.
Wow.
And I understand because a lot of things happened and a lot of bad things happened, whether it was intentional or not, who knows. But just really the infusion and almost over-regulation is the biggest change I've seen.
Well, speaking of the CFPB, obviously that has continued to be a flashpoint over the last year, with the current administration just really deprioritizing that, or even trying to shut down the CFPB. I know several folks from the Legal League that I've spoken to have talked about over the years the state side of things that you've seen. So, what are you seeing on that front specifically over this past year as these changes have been happening at the CFPB and its fate kind of stays uncertain? Are you seeing more of those state level equivalents pop up? And what does that landscape look like as you're trying to navigate, like you said, the state and the federal level?
Well, I truly, for the first time in my career, have a lot of empathy for our servicers, okay? Because they are thrown these things, and they're thrown laws very quickly. So it used to be sort of a one-size-fits-all. But to your point, in California, we have an office in California. They have AB 130, which passed relatively recently, and has to do with the foreclosure and all this due diligence that's required under penalty of perjury just to simply attempt to foreclose a junior lien. Well, that's thrown on servicers, and no one teaches you that in if you're getting an MBA, a JD, I don't care how much experience you have, they're throwing these things on you, and they're sometimes that one's actually retroactive. So state-specific things are problematic. Then you look at the loss mitigation waterfalls, which, obviously most major servicers have loans that are backed by the various GSEs as well as private investors. Well, they've got to deal with those on tight time constraints. You got to respond by X day or you can't go to sale. Then even most recently, the FHA bidding issue has been extremely complicated, right, especially in non-judicial states where the trustee is having to bid greater than total debt on properties, which creates surplus funds issues. And obviously in a place like Texas or Georgia, where it's a Super Tuesday state and we go to sale once a month, there are millions of dollars flowing in and out at the last minute to ensure everything's covered. So these are all things that are on servicers' plates and obviously on ours as well, and they have little to no time to deal with it. So it's a very, very tough environment, as tough as I've seen.
So I know we talked a little bit about the challenges that the servicers are facing in this environment. So tell me a little bit about what that looks like from your perspective. How do you do your job best to try to make their lives easier and ensure that they're covered and that you're hitting all of those checkpoints and touch points that need to be dealt with?
Yeah, that's a great question. We lean heavily on our compliance team, headed by my partner, Ryan Bourgeois, who I know is heavily involved with you guys. Ryan is an absolute star, and Ryan is in constant communication with the requisite lines of business for each state, and as soon as laws are passed, Ryan is quick to put together a memo, blast it out to clients so they can know almost immediately. I know one great example of that was last week, VA passed something thinking about the show me state issues, and VA passed something and gave instruction where, in essence, you're no longer going to have to proceed judicially to get an order to deal with a subordinate VA mortgage,
right?
And hopefully FHA follows. But it is all about communication, having boots on the ground with knowledge, and getting it out to clients and being ready to answer questions.
Could you, sort of building off that, could you talk us through what a typical sort of workflow looks like when you guys have a new case come in with a default or a foreclosure matter? What does that organizational waterfall and structure look like within your firm?
Absolutely. And the best way I can describe it is simplistically complex because
good phrase.
On paper, it looks almost like an assembly line in a factory, right? Where you have milestones because, 9 of our 10 states are non-judicial. So there's a few tweaks here and there, but they're generally the same. You have certain milestones, and that's when we're allowed to bill. So in theory, it looks relatively easy. Just do, 1 through 7 at this specific time. Right. You're good to go. However, in reality, not so easy. Obviously, you have title issues that come up, right? You have standing issues. You have successors in interest who may be writing in and are legally entitled to certain information, but you have to timely prove their successor in interest. Of course, you also have adversarial lawsuits and debt collection challenges that are far more complex than they've ever been, and clearly that's the result of advanced technology like AI. But I think any lawyer will tell you they would far rather litigate against an attorney who knows how to follow the rules than a non-attorney who's using AI, who makes it far more difficult, complicated, and expensive to resolve the issue.
How much of that are you seeing right now? Obviously, everybody, it's everywhere in the world. Everybody's trying to figure out how to deal with this, what it's good at, what it's bad at. How much are you seeing both in just homeowners, borrowers who are trying to seize on that to maybe help save themselves money or maybe even think they can avoid hiring a lawyer, versus how much are you seeing actually within the industry? Are you seeing people within the industry making those mistakes? And how do you deal with those kind of things cropping up within document integrity and other issues you're facing?
Yes. Okay. So yes to all those. We are seeing, obviously, just like I just alluded to, many, many challenges through primarily ChatGPT. And I can tell now because I can recognize the font, and it's almost like I know what it's going to say based on what the pleadings are. But that makes things more difficult. Another thing we're seeing more so than ever are fraudulent originations. And I'm not 100% sure, but I'm very confident that also is associated with AI. Because if you revert back to what happened in the mortgage crisis in the mid-2000s, they just weren't producing documents, and it was sloppy, and they were handing out money. Now there are documents, but it turns out the documents aren't legit. But they look legit.
Sure.
So we're seeing a lot of fraud. And then as far as AI in the industry itself, it certainly is being implemented on a daily a daily method through not only through law firms, but servicers and service providers. Our office has somewhat of a bifurcated approach to that. And I say that because we do not use AI to draft pleadings.
Right.
We are firm believers that attorneys went to law school for a while to learn certain skills,
sure.
Right? And they should use those skills for the clients, and that's what the clients are paying for, period. It also is easier for us to say that because we have a proprietary case management system that for several years now has given us the ability to create pleadings inside without necessarily AI, but it can help craft and get us there.
Okay.
Now, where we are using AI, and this is extremely beneficial as well, is two places. It is data reconciliation, okay, and also research. So legal research, Westlaw, LexisNexis, they all offer AI products. And I'm not exaggerating when I say before we're using Westlaw, and Westlaw, you should pay me for this because I'm going to throw you some bones here. The Westlaw product saves us hours upon hours. And a lot of our contracts, depending upon the type of work we're doing, that's not billable to the client. So what may have taken me or even several associates 4 to 6 hours 2 years ago may be accomplished in 15 minutes.
Wow.
Which is a win-win for everybody.
Sure.
Right? And then back to that data reconciliation, whether it's our HR department getting ready for open enrollment like we're doing right now, the end of the year, or accounting bouncing off invoices to ensure that numbers are correct. The amount of things it can accomplish in just lightning speed is fascinating. And we're just at the tip of the iceberg, as we all know.
Yeah, it's going to be interesting to see how things progress over the next few years and beyond. Well, stepping back from the AI topic for a second, let's go back to the human error side of things. So what are some of the most common mistakes you see crop up in the things you deal with, whether it's on the servicer side or other attorneys or even attorneys in your own firm? Where are the error points that you see crop up most often?
Sure. Our office, we never make errors. So
That's
I can
good
just
to
go
know.
ahead and
put it out there.
I'm being facetious there, of course. I will start with from the servicer side, and they're getting a lot better about this. But there's a reliance on technology, of course, right? And a lot of us are forced to communicate through various vendor systems, Black Knight, and I don't know if this was actually Black Knight, but I was traveling last week and I had dinner with an investor who sends us a lot of files throughout various servicers, and he was frustrated because we had a case that was heavily litigated, for years, and finally got to judgment. We won, and there's an email chain with 3 parties on it: the servicer, the law firm, and the investor. And again, this investor is hands-on, pretty much calls the shots, and the servicer and the law firm move accordingly. Well, they were adamant about wanting to make a certain sale date, and that's in the email. We're all on it. Well, in this specific vendor system, the law firm doesn't have the ability to remove a litigation hold to actually post it for the next sale. That has to be initiated by the servicer. So we followed up a couple times, and by the time it ultimately got released, we had missed the posting deadline. So despite the fact that all 3 of us were at a meeting of the minds on the email, the technology actually acted as an impediment. So there's pros and cons to the technology thing.
Is there an example of a case you can think of where maybe a challenging case or one that was particularly sticks with you that it really came down to legal strategy and just that human element of figuring out the best way forward?
Yes, there is. There was a case several years ago in the Rio Grande Valley in Texas, and anyone who has dealt with mortgages or litigation knows that the Rio Grande Valley is extremely borrower friendly and just as much anti-bank. So it's not good to be on the bottom line of the V in the lawsuit if you're in the Rio Grande Valley.
Okay.
Well,
good to know.
It was relatively contested, nothing too bad we're worried about. And all of a sudden, out of nowhere, the judge rules against us at the summary judgment stage. And I'm shocked, but it was such a bad ruling. It's like, we're going to appeal this. We're going to get it overturned. We appeal it. Obviously, the issue with the appeals, although the upside is they get it right 99% of the time, the downside is it's expensive and it's extremely time consuming. And you can't just ask for status. It could be years. So we file this appeal. Then we're talking to the servicer, and it turns out that through a prior counsel, this same debtor had entered into a settlement agreement with the servicer in which they accepted a large sum of money in agreement to not contest any future foreclosures. Well, clearly we didn't know it at the time, but that's not what happened by this individual fighting us
right.
and ultimately prevailing, at least at the trial court level. So at that point, we have a breach of a settlement agreement, which is a breach of a contract. It's clear that he got the funds. So we file a breach of contract suit seeking foreclosure as our remedy instead of getting our money back. And we're about to win. Suddenly he drops the appeal. Money and time is saved. So that was a fun one.
Well, I know that mediation is something that is perhaps I've heard from some becoming more common in these cases. What's your perspective on that? Are you seeing that become more common? And what are the sort of takeaways from dealing with that? What are the challenges? What are the benefits?
I am a huge advocate of mediation, even when it seems meaningless, for lack of a better term. because everyone, whether it's a client, and usually our clients are, they're pretty buttoned up and they know what they want or what they're willing to do. But if you're dealing with the borrower, sometimes they just want to tell their story, and they have the ability to do that, right? It might not be all about the house. It may be about the personal items inside because they grew up in that house and it was their grandmother's. A good mediator is always able to pinpoint that it thing, whatever it may be. And if you can locate it, that case is going to settle 99 out of 100 times. And another thing I always advocate, even if the case isn't going to settle, is for the mediator to make a mediator's proposal. So the mediator is, a good mediator at least, is going to give you an unbiased opinion of what they think a jury might do. And sometimes that makes us reevaluate the way we analyze the case. Maybe we thought we were in a better position than we were, or maybe they were. But oftentimes, if you can get a mediator's proposal, even if it doesn't settle at mediation, it may well settle down the road, because that's something for both parties to think about and get real.
Sort of building off that, obviously, the nature of default law, you're dealing with, you're trying to do right by your clients, and you're trying to balance that against the realization that you're dealing with borrowers who may be having the worst week of their life. They're in a really tough situation, and everyone is obviously scared when the word foreclosure even enters the process. So outside of a mediator situation, how do you balance that need to serve the clients versus still maintaining a level of compassion and interaction with those borrowers in these situations?
Yeah, to me, it is all about communication 101. And, most people are not in these situations being, i.e. a defaulted situation, because they chose to be. Okay? Sure. Something bad happened. Everybody's got a story. Maybe their fault, maybe it's not, but it's kind of irrelevant at that point. So be a good communicator, show them empathy, okay? And really, it kind of goes back to the same principles that our parents would teach us when we were children. Treat people the way you'd like to be treated. And I have found that if you do that, they're more willing to open up to you and ultimately reach some common ground. And that always is a far more better way to communicate than just the adversarial, give me your name, what do you want? That gets nowhere.
Yeah. Well, you spoke about just some of the challenges of compliance and keeping up with new laws being passed at the state level or federal level, all that. So what is some advice you and your firm would give to servicers as far as how can they operate on a more proactive basis as opposed to constantly being reactive?
Yeah, that's a great question. I have seen more of this truly in 2025 than I have ever seen. And I'm not sure if that's because of the unique, not only state-specific but federal laws that have been passed. But what a lot of our services are doing now is they're reaching out for, a phone call and or a legal opinion on an issue before it's even been referred. And it's just maybe we have some fraud loans. How do you think we should handle these? And they're much more willing and accepting of our feedback. Now, ultimately, our job as their lawyers is to counsel them, right? And give them pros and cons and risks. Their job is to run the business and ultimately make the best business decision for them. But if they're even going to give us a platform, which I'm finding they're willing to do, to give them pros and cons, I find more often than not that they're making prudent decisions that are ending up more amicable than they were previously.
Well, we obviously talked about AI, and that's such a big hot topic right now. But beyond AI, what are other areas where you're seeing the technology advancing in a way that's helping the servicers and the law firms? Are there certain areas that are changing how you do your work beyond just the big AI question?
Well, yeah, absolutely more than AI. There technology, as you know, whether it's just apps you download on your phone or even Copilot offered through Microsoft, right? It's everywhere, and it is making everything we do more efficient, quicker. Now, it's not always accurate, so there is a QC element to that. And we have training on that all the time to ensure that just because answers are spit out or you believe data has been double-checked, it is still your work product. If you're an attorney, it's still your bar card. You are signing that pleading. You need to make sure that it's accurate. But it is speeding everything up.
Mm-hmm. Are you seeing common misconceptions that people might have about what you do, about foreclosure and default law? Obviously, like we said, it's a topic that there's a human element. There's a lot of emotions involved a lot of times. So do you encounter misconceptions, whether from just the general public or even from servicers that you work with, about what you do and how you do it?
I do, although to go back to the beginning of our interview, I used to do personal injury work. Yep. So I was an ambulance chaser, for lack of a better term. So I don't know if I moved up, down, or sideways in the world to being a foreclosure attorney. But I look at it, and I think most people look at it as us enforcing contracts. Because at the end of the day, now, look, I have seen contracts that people did sign under duress or were forged, but 99% of the time, this was a handshake agreement. People knew what they were getting into, and they breached it for one reason or another. And there are loss mitigation programs that can help, but for the most part, there's not as much animosity as there was before.
It's interesting. Well, looking ahead, obviously we're not even through the whole year yet, but we're coming up on the end, and it's been a very hectic and unpredictable year. What are you watching as far as case law or governmental regulations? What are the top three things that you guys have on your radar as far as we got to keep an eye on how that develops? Yeah, absolutely. The first would be increased regulation. Mm-hmm. I mean, as we alluded to previously, CFPB is somewhat in flux. I mean, I believe they're scheduled to run out of funds in early 2026. Yep.
Who knows what happens there?
Sure.
Could be bad, could be good. Who knows? But one thing that is certain is states will continue to intervene, especially certain states. We have an office in Denver, and obviously we operate in California, and both AGs and legislatures there pass legislation as frequently as they can. Mm-hmm. Not necessarily that are anti-bank, but it's just more loops, right, that go through. So increased regulation, I think, is an absolute guarantee. Another thing is consolidation. You're looking at, Rocket and Mr. Cooper just, that happened just Q1, I guess, last month. So they're the biggest servicer out there, but also amongst law firms, because it's an extremely expensive space to practice. And obviously everybody's dealing with it, not just this industry, but inflation stuff. So you see a lot of firms, whether it's a merger, an acquisition, a purchase, that's going to continue, I certainly think. And the third thing would be that technology is no longer optional. It's a necessity. And I mean, everyone knows that to a certain extent. Of course, we all have our computers and our phones in our email, but I'm talking about things like AI, picking up numbers, inputting them automatically, document integration happening at lightning speed.
Sure.
I think that is going to be the norm very, very soon, perhaps as soon as this year.
Well, we're just about at the end of our time, so a couple more questions to wrap up. Just from hearing you talk about the course of your career, it seems like where you wound up is definitely checking many of the boxes of what you wanted to do setting out. But obviously everybody has stressful days. They have challenges. So what keeps you motivated and engaged and doing what you do at this point in your career?
Yeah, that's a great question that I think about all the time. Because you're right, as you kind of spell out what I thought my skill sets were and what I wanted to do, and then I'm here, it certainly does sound like it kind of worked out. I don't always agree with that, but it's the people. First and foremost, not only our employees, but again, their tenure, like I talked about. It's the reputation of our firm, because Mr. Barrett was a pioneer in this industry, and just to be associated and sit in the same chair he sat in means a lot to me personally. And I know a lot of the industry vets agree the same. And then I guess somewhat piggybacking on the people thing would be leaving a good influence for my children. I have 3 young girls, 12 who doesn't think she's young anymore, but 9 and 7. And I've been in this job over 19 years. They have seen highs, they've seen lows, they've seen me work my tail off, and they've seen me take pride in that. And if they can gather that from me and implement that, and if it can have any role in their lives whatsoever, I would consider that a success.
It's a good perspective. Well, last question before we take off. What is one final piece of advice or perspective or just a final thought you would like to leave with our audience here at the MPA Access Show?
Sure thing. It's a little bit like the Mamba mentality for those of you who are basketball stars or basketball fans.
There might be some watching. You don't know.
Exactly. And enjoyed Kobe Bryant. Work on the little things. Work on them to perfection. Do them repeatedly. Okay? And, take pride in working when no one's looking. You don't have to be the last one at the office just so they can say, David was the last one here. He must be working his tail off. And big things in this industry I have learned, they're not necessarily like the big packages under the Christmas tree that our kids run to first and want to open up. Big things come by perfecting and doing the small things correctly. So focus on the small things and the big things will come.
It's a great thing to leave us with. Awesome. Well, thank you so much for your time today, Robert. We really appreciate getting some time with you. I'm sure we're going to see you at a bunch of our events here in 2026 coming up, so stay tuned. And everybody else, thank you for tuning in to the MP Access Show, and we will see you next time.